request the dignitaries to come on the stage, please. And welcome to the third edition of the International Commercial Arbitration Conference in Ahmedabad. The theme for the conference is International Commercial Arbitration, the Dawn of a New Age. We look forward to a day filled with interesting discussions on contemporary international arbitration topics. I would now like to invite upon stage Mr. Madhukeshwar Desai, CEO of MCIA, to give opening remarks.
Good morning, ladies and gentlemen. Respected Justice Shah, respected Justice A.J. Desai, Mr. Kamal Trivedi, Mr. Vyas, Ms. Hetal Pawar, Mr. Prithvi Jadeja, respected honorable judges from the Gujarat High Court that have joined us here today, Mr. Kita Mittal, members of the Gujarat High Court Arbitration Center, members of the Gujarat High Court Advocates Association, my dear friends. On behalf of the MCIA, I welcome you here today for the third annual conference titled The Dawn of a New Era. A few weeks ago, when I was in Mumbai, somebody asked me, why is it that we're doing a conference in Ahmedabad? Why Ahmedabad? Why Gujarat? And my response to them was, why not? Ahmedabad is one of the fastest growing cities in the country. Gujarat has some of the highest economic activity over here. It has the longest coastline. It's one of the most industrialized states. It attracts some of the greatest number of FDI investments in the country today. It's also home to one of the richest people in the world. Why wouldn't you want to have a conference over here? But for the MCIA, it's something a little more special. The legal community in Ahmedabad and in Gujarat has been very, very supportive of us, India's first truly homegrown international arbitration center. And every time we meet with individuals over here from the legal community, they say with pride that we're supporting the MCI, we're supporting an Indian arbitral institution. In fact, it was just 1 year ago that we had the last event. And in that time, we have done seemingly well. We are now 65 cases that we are administering over 65 cases. Just last year, of the cases that we administered, 92% of them completed within the 18-month timeline. Of that, of course, 3% were challenged in a court of law, all of which were dismissed. We have really strived very hard to bring international best practices and efficiency to arbitration in India. The success of the MCI would be incomplete without mentioning the support of the courts. The Honorable Supreme Court of India has referred last year 5 international commercial arbitrations to be administered under the MCI rules. In addition to this, we have played a small part in pushing for, I wouldn't say a personal agenda, but an agenda that we work very hard for. Our institution is led by a woman, but it isn't enough for us. We have pushed to appoint as many women arbitrators as we can for the appointments that have been made. And last year we had 30% of all appointments made under the MCI as women. I hope that over the next year we continue to do well, and I come here again in the April of 2024 and give you a better report of the work that we have done, but with one distinction. I hope I can share with you a greater number of Ahmedabad-seated MCI arbitrations that I can report. Thank you so much.
Thank you, sir. I would now like to invite upon stage Mr. Prithvi Jadeja, President, Gujarat High Court Advocate Association, to give the welcome address.
A very good morning to all present. Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India, Honorable Justice A.J. Desai, Acting Chief Justice High Court of Gujarat, Shri Kamal Trivedi, Advocate General State of Gujarat, Shri Vyas, Additional Solicitor General of India, Honorable Judges of the High Court of Gujarat, Justice Mittal, Justice Puj, Senior Advocates, my esteemed colleagues at the bar, ladies and gentlemen. On behalf of the Gujarat High Court Advocates Association, I welcome you all in today's seminar. I am very happy and proud to state that this is the third seminar hosted by the Mumbai Center for International Arbitration in Ahmedabad. And we, the Gujarat High Court Bar, has been associated with them since inception. In the three modes of alternate dispute redressal, that is Lok Adalat, mediation and arbitration, arbitration has been the most sought after one. The theme of today's seminar being International Commercial Arbitration, the dawn of a new age, is a very relevant topic in the current times. I must congratulate Madhukeshwar and Niti along with their team to decide such an important topic as the main theme of today's seminar. With the influence of artificial intelligence in all walks of life, our legal field will no longer be lagging behind. Influence of artificial intelligence is already spoken about in the corridors of the Supreme Court, and I am sure that very soon it shall be a part of our lives, and most importantly, the way in which court proceedings and arbitration is functioning. Arbitration, because of its versatility, lean structure, and openness, would probably be able to adopt technology, including artificial intelligence, faster than courts, and would therefore guide the entire fraternity on advantages and perils of the same. Today, we shall also be discussing the latest developments in the law of arbitration and about the innovative remedies of international commercial arbitration. MCIA has lined up eminent speakers and moderators who will be conducting the sessions today. In my view, institutional arbitration is the only way to make the arbitration process a successful alternative dispute redressal mechanism. By the end of today's seminar, you will realize the importance of the subject, and I confidently say that you would gain immense knowledge from the experts in the field of arbitration. I wish all the organizers, sponsors, a great success for today's seminar. Thank you very much.
Thank you, sir. I would now like to call Mr. Kamal Trivedi, Advocate General of Gujarat High Court, to address the event.
Respected Shri Mukesh Bhai, Honorable Judge Supreme Court of India, Respected Shri Ashish Bhai, Honorable Acting Chief Justice, High Court of Gujarat, Learned Registered Solicitor General, Devang Bhai Vyas, present as former Honorable Judges of the High Court of Gujarat, Justice Geeta Mittal, Mr. Madhukeshwar and Ms. Niti Sachdeva, the backbone of Mumbai Center for International Commercial Arbitration, our President, Mr. Jadeja, and the Vice President of Gujarat High Court Advocates Association, and the distinguished gathering of learned advocates, learned panelists, learned moderators, participants. Very good morning to one and all. It is indeed a matter of immense pleasure for me to be the part of this conference on international commercial arbitration, the dawn of a new age. And it's heartening to note that it's organized at the behest of MCIA in association with Gujarat High Court Arbitration Center and Gujarat High Court Advocates Association. I think Mumbai Center for International Arbitration deserves my sincere commendations for providing a very invaluable platform for knowledge sharing and engaging in insightful discussion on various nuances of arbitration during the course of the day. And I'm certain that it raises the knowledge, information, new perspectives, and the broader horizons. As we know, for our country, arbitration is not a new phenomenon. If you can recall, maybe more than 3,000 years back, when the Battle of Mahabharata was fought, Lord Krishna had played a role of a great mediator and arbitrator. Even in olden times, in villages, eldermen or a panchayat were used to sort out the differences among the villagers, and their decision was considered to be a sermon for all. Even in China, 100 years back, I was told, the people used to get together in tea houses and get the differences sorted out over a cup of tea. They call it settlement tea, Shi Jiang Cha. So in a lighter way, somebody says, in China, tea can fix everything. So hope can arbitration also fix in our country. Coming to the subject, as we all know, today arbitration is being promoted all around, and it is grown in leaps and bounds. Professor Richard Susskind, a very eminent professor, has once said, with reference to the world of arbitration, just like a spread of pandemic, the technological advances are taking place so fast, with an overwhelming speed, if I may say so. And according to him, in next 2 decades, maybe less, the changes in this arbitration world will be more dramatic than what we have seen in last 2 centuries. From Indian perspective, I must say, the dawn of a new age has already begun, which can be appreciated in terms of several developments. Let me recount a few of them. First and foremost, there used to be the times where institutional arbitration was being cursed. People were of the opinion that it's very expensive, it's very rigid, regimental, very formal. But that misconception has now been given a go by. Today, people are preferring institutional arbitration, owing to various advantages, like we have a benefit of panel of expert and experienced arbitrators. We have a set procedure which is predictable in view of the rules having been laid down by the arbitral institutions. We have administrative support, we have infrastructure support. This is cost effective, confidentiality is maintained, and above all, 2 factors: time-bound rendition of award and credibility of the institution, which also facilitates the rendition or the enforcement of the award. So because of this, today institutional arbitration has become a very favorable means of resolving the dispute. In my view, this is first development is very important. Secondly, we have got some finest institutions dealing with international commercial arbitration having been established, like Indian Council of Arbitration, MCIA, Delhi International Arbitration Center, Bangalore Mediation and Arbitration Center. We have Nani Palkhiwala Arbitration Center, and we have now in Gujarat, Gujarat High Court Arbitration Center. And if my memory serves me right, I may be corrected if I am wrong, this center started in February 2021. For 9 months, there were only 2 arbitrations. Today, that center can boast to tackle 136 arbitrations, out of which 14 are already disposed of. So in my view, this is a very, very important development towards a new age, which according to me has already come. Then we have the establishment of hub for international arbitration. I may not say that this development has already taken place, but very likely to take place. Today we don't have amongst us the learned Solicitor General. But what he said the other day in one of such conferences, that why can't we look forward to the establishment of arbitral townships? He was absolutely right. Why can't we have this kind of a township where we have all the facilities? Facilities not only for the purpose of conduct of arbitration, but for the purpose of lodging, boarding, recreational facilities, technical support, administrative support, infrastructure support, so on and so forth, which is acceptable to the world community for the purpose of seat as well as venue. And why can't we have a jurisdiction akin to Section 17, Section 34, Section 37 within that particular township, with one court of appeal, that's the Supreme Court, We'll go to Mr. Shah at that time. Before that, we will not disturb. This is possible, plausible. I was referring to a gift city in Gandhinagar. I don't know how many of you have seen that. I request, please see. It is coming up so fast. Central government has announced setting up of the International Commercial Arbitration Center over there. It is a special economic zone. It is International Financial Services Center with lots and lots of tax exemption. We can look forward to this kind of development taking place in the very near future. Another development is our parliament, our lawmakers. And I must say that we must thank them, we must congratulate them. The first law in our country was Arbitration Act of 1889, when the arbitration was recognized as statutorily for the first time. The journey from 1889 to 1923, very eventful, and more particularly last decade. Parliament has been live as to what is happening in the world. And to cope up with that, they keep on incorporating amendments in the Act, one after another, plethora of amendments. Like 2015, you must have witnessed number of amendments, important of which are Section 8 came to be amended to show that an entity which is not a party to the arbitration agreement can also participate by claiming that he is claiming under or along with him who is a party to the arbitration agreement. 12.1 came to be amended so as to enable the arbitrator to make a disclosure. Earlier there was a very blank canvas. Now we have Schedule 5 which lays down these are the matters in respect of which, if at all, if you feel that you are concerned, make a disclosure in a format given in Schedule 6. New Section 31A came to be added, which is now providing that what should be the cost for the arbitration proceedings and how can that fall in the award. 34 came to be amended, and perhaps it is a great boon, whereby grounds like patent illegality, perversity, like reappraisal of evidence have been taken out so far as challenge against the International Commercial Arbitration Award is concerned. 36 came to be amended to make it compulsory that you must file the stay application and get the award, otherwise there will not be automatic stay, which was there prior to 2015. Then 2019 amendments, so many amendments, important of which is Section 29A subsection 1, which says 12 months time limit for rendition of the award is not applicable to international commercial arbitration. Then we came in 2021, good number of amendments, important of which is if the award is obtained prima facie by way of fraud or corruption, in that eventuality you deserve automatic stay. So Parliament has been very live, and these amendments show that we are determined to see that arbitration proceeds in this country in a seamless fashion. That's how dynamically the amendments are being carried out. Another development in my view is there is a change in the outlook of the court. The superior courts, what I mean is the high courts and the supreme courts, they have started pushing the parties to arbitration. That was not so. Judicial interference is perhaps now is this possible available. And we find judgments being rendered day in and day out, like PSL Wind Solutions, wherein for the first time Supreme Court said that it is available to an Indian party to dedicate a foreign state for arbitration. Judgment like Amazon, where for the first time the Honorable Supreme Court enforced emergency award rendered by the emergency tribunal appointed by SEAC. So this is a very important development whereby the outlook of the courts has been changed. Another development, if I may say so in a very respectful fashion, COVID-19 pandemic. That pandemic has taught us so many things. I don't know how many of you had imagined prior to the initiation of the pandemic that we will be doing our hearings virtually. Nobody knew. Nobody knew. And perhaps today you are more comfortable with virtual hearing rather than physical hearing. If a choice is given, you will say, no, I'll go for virtual hearing. In terms of convenience, in terms of putting more amount of work, which was not feasible in physical hearing. And above all, it cuts down your traveling cost, it cuts down your lodging and boarding cost. So it's a great development which I feel to be taken into account. Another development, you all know, we have now availability of the facility of real-time transcription, which you can view in your iPad minutes. We have now the availability of facility for emergency tribunals, emergency awards, for getting stay orders during the pendency of the constitution of the arbitral tribunal. And last development in my view is, we all talk about that, is introduction or availability of artificial intelligence and its application like ChatGPT, which perhaps helps us in analyzing large amount of data, in segregating data, in drafting pleadings, in reviewing pleadings, in selecting arbitrators, in selecting experts, so on and so forth. So in my view, looking at these developments, this is the dawn of a new age. You can't say new age has not begun. But at the same time, there are certain areas which require our attention. Let me take this artificial intelligence first. In my view, it's a very dangerous proposition. In Estonia, the arbitration proceedings have begun by AI judge. In China, the courts handling small claims are manned by AI judges. So if you are not applying your discretion, perhaps it is a double-edged sword. Tomorrow, one should not be surprised if a human arbitrator is replaced by AI arbitrator. But speaking for myself, I am against that. To decide a matter by way of adjudication, while sitting as an honorable judge in the Supreme Court or in the High Court, you require human feeling. You require a philosophy, maybe for or against, a social philosophy, a political philosophy. AI arbitrator cannot afford to have all these things. So that's the area where you all people have to put in your mind as to what extent one should go, beyond which we should not go. And then you know very well, a software related to AI is capable of being hacked. So tomorrow you may find a fraud, commission of undue pains, so on and so forth. The second area in my view which requires consideration is an appeal to the lawmakers. Many grounds under Section 34 for challenging the International Arbitration Award are not very succinctly laid down in the Act. With the result, we find various judgments. Like one of the sections of Section 34 says, if the International Arbitration Award is in contravention of the basic notion of justice and morality, which shocks the conscience of the court, can be set aside. I wonder, my Lord, appeal to my Lord Mr. Justice Shah. My Lord's conscience may be shaken, supposing in a given case, but that will not be a common conscience with everyone. What may shock my conscience did not shock your conscience. What are the parameters? What is the barometer? Is absolutely today left to the discretion of the Honorable Court. We need some kind of guideline flowing from the law itself as to what are the instances of morality, what are the instances of justice, whereby you can say that this award is against the basic notion of morality or justice, and what will shock the conscience of the court. Similarly, another grey area where the debate has been taking place in and out, whether the award can be modified or not. Today, we depend upon the court's verdict. One verdict says that award cannot be modified. It may be set aside. Whereas some courts say that no, it may be modified in the sense that if there are different claims and by applying a doctrine of severability, the bad parts can be set aside, good parts can be upheld. So that also to be kept in mind by the lawmakers. And lastly, which perhaps I feel very important, today banking and financial sector of our country is not fully covered under the umbrella of arbitration. We have a limitation. We have a limitation under the RBD Act. We have a limitation under the Surface Act, which have provided remedies by themselves. Our financial sector is highly regulated by the regime of regulation like RBI regulation, like SEBI regulation, like RDI regulations. In order to see that these sectors are covered, maybe the complex matters can be left for the adjudication by the national courts. But why can't we see that the major issues of banking and financial industry are covered? But for that purpose, I've been telling people again and again, we need to have, or is a dire need for creating a pool of arbitrators. Normally we expect the honorable judges, the lawyers to be the arbitrators. I pose a question to myself, why can't a technocrat be an arbitrator? An economist be an arbitrator? The chartered accountant and cost accountants be arbitrators? So there is a need for creating a pool of expert arbitrators. And apart from MCIA, we need to have dedicated institutions providing platform for resolving this kind of disputes relatable to financial sector. For that, we have a prime finance in Netherlands, FINRA in US, we have FDRC in Hong Kong. We do not have any kind of this institution in our country. So we should look forward to that. Friends, I think I should not take much time. We are also looking forward to being enlightened by my speakers to follow hereafter, and more particularly Justice Shah and Justice Desai. I wish you all a very eventful day today, and I'm sure that you are going to discuss various aspects, and more particularly please discuss in detail the artificial intelligence part, because which is going to be the, I think, the need of the hour in future. Once again, thanking you very much, more particularly MCIA and Advocate Sri Nitin Mehta, for giving me an opportunity to share my views this August gathering. Thank you.
Thank you so much, sir. Unfortunately, Mr. Tushar Mehta could not make it to the event due to his busy schedule, as he is occupied in preparing for an important matter pending before the Supreme Court. I am now happy to invite on stage Honorable Justice Mr. A.J. Desai, Acting Chief Justice of the Gujarat High Court.
Good morning, Namaskar. Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India, Mr. Kamal Trivedi, Advocate General, High Court of Gujarat, my esteemed sister and brother judges, Gujarat High Court, Shri Devang Vyas, Additional Solicitor General, Gujarat High Court, Mr. Jadeja, President of our Gujarat High Court Bar Association. It gives me great joy to be in the esteemed company of honorable dignitaries and experts who have come from other countries and the respected members of the legal fraternity. Let me first congratulate the Mumbai Center for International Arbitration and Gujarat High Court Arbitration Center, as well as Gujarat High Court Bar Association, for making such a significant progress in promoting institutional arbitration. The theme of today's conference is International Commercial Arbitration, the Dawn of a New Age, a topic which is very relevant in today's context. I am told that there are 4 technical sessions planned for today, and these are all very interesting themes. I have perused the list of speakers, and I can certainly say that it promises to be a very interesting day, full of dialogue and discussions. In the current economic scenario, international investment, trade and commerce are being rapidly developed everywhere. India is very much in the midst of globalization of trade and commerce, and some of the largest companies of the world are doing significant business in India in collaboration with Indian parties. When there is business, there is bound to be a dispute. International arbitration is a leading method for resolving disputes arising from international commercial agreements and other international relationships. As with arbitration generally, international arbitration is a creature of contract, that is the party's decision to submit dispute to binding resolution by one or more arbitrators selected by or on behalf of the parties and applying adjudicatory process, usually by including a provision for the arbitration of future disputes in their contract. The practice of international arbitration has developed so as to allow parties from different legal and cultural backgrounds to resolve their disputes, generally without undergoing through the formalities of their respective legal systems. It provides the necessary flexibility in conduct of arbitration, binding resolution without recourse of appeals except to challenge the award on very limited grounds, efficiency in terms of time and cost, and enforcement of mechanism throughout the world based on New York Convention. As said earlier, business dealing naturally gives rise to disputes, but when there are international parties, there are added difficulties often involving various jurisdictions, diverse legal systems, different procedures, and sometimes more than one language. Therefore, dispute settlement has become an important area in international contract and trade. Settlement of dispute in trades is made either by litigation in court or by alternative nature dispute resolution in international business transactions. Arbitration has been used by parties involved in commercial disputes for many years and provides a good alternative to litigation. Everybody sitting here is aware the state of Indian judiciary and the pressure it has due to huge case load. There is no doubt that the alternative dispute resolution is possibly a mechanism which can cater the need of ever-growing disputes in the field of international business. The court can definitely play a crucial role in aid and support to arbitration as envisaged in our laws. The government of India has undertaken many measures to ensure improvement ranking in the ease of doing business index. Due to such efforts, India stands at 63rd position at World Bank's report on doing business in 2020 from a previous standing at 138th position. Enforceability of contracts along with the streamlined dispute resolution mechanism is a significant determination factor for ease of doing business in a country and to make it an effective destination for investments as well. Realizing the importance of the aforesaid, multiple changes have been introduced in India's arbitration regime during last decade. As a result, increasing number of judicial decisions and legislative measures have been trying to radiate the pro-arbitration approach of the government of India. With a view to make India a hub for international commercial arbitration, the central government has notified number of amendments of our Arbitration and Conciliation Act of 1996. I am not going into the significance of each of them, as I assume those will be discussed in some form or other during the course of today's conference. One of the significant steps taken by the central government via this Amendment Act is to promote India as a hub of international commercial arbitration is the deletion of 8th schedule. The 8th schedule contained a comprehensive list of qualifications an individual needs to possess to be appointed as an arbitrator. However, one of the major drawbacks of the 8th schedule was that it was believed to have severely restricted the potential for appointment of foreign lawyers as arbitrators in India. The current rules published by the Bar Council of India allowing foreign practitioners to participate in the arbitral process in India will also go long way in establishing India as a hub for international commercial arbitration. Many institutions in countries throughout the world have drafted set of rules for conduct of arbitration in the hopes of attracting arbitration business to their centers. Mr. Kamal Trivedi has given the details how many institutions are dealing with this. The Gujarat High Court Arbitration Center was inaugurated on 28 February 2021. It is a non-profit venture which focuses on providing eminent facilities for conducting arbitration to different stakeholders at nominal charges. The center has fully digitally equipped meeting halls with experienced secretarial and other staff services. The arbitration center has independent lounge areas for visitors, lawyers and arbitrators. The The center also helps in coordination proceedings between parties, arbitration proceedings completed in time frame schedule. It also keeps the digital archives of the arbitration proceedings record and award. I was told that arbitration center has so far received total 132 cases for arbitration. The arbitral tribunal has disposed of 14 cases where the amount involved is more than 47 crores. Hearing of remaining cases is in progress, and the arbitration center is being utilized frequently by the government department and private parties for conduct of arbitration cases on payment of nominal charges. There are many good arbitral institutions now developing in India, such as Mumbai Center for International Arbitration, which has taken a lead in organizing such a wonderful conference with important topics being discussed for the development of arbitration as a process in India, jointly with Gujarat High Court Arbitration Center and Gujarat High Court Bar Association. Some of the other institutions which I know are making great contributions are institutions such as Delhi Arbitration Center, Nani Balkiwala Arbitration Center, etc. There is also a proposal ready to appoint or nominate institutional Section 11 of the Act for appointment of arbitration. In my view, considering the ambit of Section 11 and being in the initial stage of conduct of arbitration, this is one of the best stages where court can contribute significantly by involving arbitration institution at the very early stage and support the movement of institutionalism of arbitration in India. We have definitely come a long way in the development of arbitration in India, but there are many areas which require attention. I am sure discussion at conference like this will make a huge difference and bridge the gap. I wish the event a great success and best wishes to everyone involved in this conference. Thank you.
Thank you, sir. I am now glad to invite our chief guest for the event, Honorable Justice Mr. M.R. Shah, Supreme Court of India, for his keynote address.
Very warm good morning. Namaskar. Justice A.J. Desai, Acting Chief Justice of Gujarat High Court. Shri Kamal Trivedi, Advocate General. My esteemed brother and sister judges of the High Court of Gujarat, Shri Devang Vyas, Additional Solicitor General, President of the Bar Association, Sri Jadeja, Justice K. Buch, former Judge, Gujarat High Court, Shri Madhukeshwar, CEO, Ms. Nidhi, other participants, my dear friends, ladies and gentlemen. First of all, I may answer what Madhukeshwar has said, that why Gujarat? But I must say he has not said that the truth thing, the correct things, because Mumbai Arbitration Center is in love with Gujarat and Ahmedabad. Therefore, this is the, I think, fourth conference organized here. And fortunately, in all these seminars and conferences, I participate, because I am also in love with the Mumbai Arbitration Center. Ladies and gentlemen, once again I am honored to be a part of today's conference on a very important topics in the international commercial arbitration, the dawn of a new age, organized by the Mumbai Center for International Arbitration in collaboration with my own institution, Gujarat High Court Arbitration Center and the Gujarat High Court Advocates Association. I am very happy to know that three very important stakeholders in this justice delivery system have joined hands together, which will enhance the speedy resolution of the disputes between the parties, more particularly commercial disputes. I may say one thing that I am always saying that Kamal Bhai has already played his game. He has already made the runs. Thereafter, Justice Desai, and so far as I am concerned, I will be giving a finishing touch to the game. So, if any repetition is there, please excuse me, because Kamal Bhai is always so meticulous and precise. Correct? He tells everything and thereafter he doesn't leave anything for others. So, please excuse me for that. The present day discourse of the need to evolve alternative dispute resolution mechanisms tends to focus upon the large and almost unmanageable docket of litigation before courts. The problem of arrears has necessitated a search for alternates. India is waking up to the realization that its dispute resolution system needs to keep pace with the rapid economic growth. While its economy grows at an impressive rate, the Indian justice delivery system has struggled to keep pace. Although the Indian judiciary is always trying its best, still it is very difficult for the judiciary to tackle with the problem of delay and arrears. The problems which arise in the resolution of disputes through litigation broadly are delay, expense, rigidity of procedures, and a reduction in the participatory role of parties. Therefore, it is necessary to find out other ways to resolve the dispute between the parties, more particularly the commercial disputes, and the arbitration is found to be the most favored alternative dispute resolution mechanism, which is said ADR. The arbitration has a very long history in India, as said by Kamal Bhai. In ancient India, times people often voluntarily submitted their disputes to a group of wise men of a community called the Panchayat for a binding resolution. The arbitration law in India started its journey as far as back in 1772, when during the British rule, the Bengal Regulation Act came to be enacted, which provided a reference by a court to arbitration with the consent of the parties. Thereafter, Arbitration Protocol and Convention Act 1937 came to be enacted, and thereafter the Arbitration Act 1940, and thereafter the Arbitration Act 1996. There are various amendments from time to time. In Arbitration Act 1996, thereafter in 2013, 2019, which are always the subject matter of litigation before the courts. I may say with great proud and privilege, being a part of the justice delivery system and judiciary, that whenever the occasion has come, the judiciary has intervened and tried to interpret the law, and more particularly in favor of the arbitration. And not only the arbitration, but finality of the arbitration, which has many a times necessitated the amendments in the Arbitration Act, which have been referred in extenso by Kamal Bhai. Today, arbitration is a very popular mode of alternative dispute resolution in the commercial world, and one can find an arbitration clause incorporated in majority of the business contracts. Parties in India prefer either ad hoc arbitration or institutional arbitration. The ultimate goal of the ad hoc arbitration and the institutional arbitration is the early, speedy and timely resolution of the commercial disputes and or the family disputes. Everybody knows the advantages and disadvantages so far as both the ad hoc arbitration and international institutional arbitrations are concerned. In ad hoc arbitration, parties regulate the arbitration proceedings themselves. In contrast, the institutional arbitration, the parties are governed by the procedure and the rules, and the regulations are framed by the arbitral institutions like Mumbai International Arbitration Center, Gujarat High Court Arbitration Center, and other institutional arbitration centers. There are bound to be advantages and disadvantages insofar as the ad hoc and the institutional arbitrations are concerned, which everybody know today, as the same has been discussed time and again. However, there shall be an awareness to adopt the ADR mechanism to resolve the dispute through arbitration. Though the parties in India prefer ad hoc arbitration, however, according to me, for that the parties have to approach the courts to appoint the arbitrator, and the delay starts as it is experienced that even the courts are not in a position to dispose of Section 11 applications at the earliest. That thereafter the parties shall have to agree on the procedure to be followed in the ad hoc arbitration. On the other hand, in the institutional arbitration, parties know the rules and regulations and the procedure to be followed. The cost of the arbitration proceedings, etc., I may tell you that because of so many reasons, the cost effect in the arbitration, in the ad hoc arbitration, correct, is phenomenally increasing. And sometimes when I discuss so many things with so many stakeholders, they say that, sir, it is better now that we may not have the arbitration agreement that there is an arbitration. That is why there is a necessity and requirement, correct, that it should be having a less cost effect, which the institutional arbitration, correct, everybody knows when they approach the institutional arbitration that I have to pay this, correct, this will be the cost, whether I should not go or not. That is, according to me, this is one of the best, you see, feature and the benefit so far the institutional arbitration is concerned. Every time, every institutional arbitration conference or the seminars, I have by and large advocated for the institutional arbitration. On the other hand, the institutional arbitration, parties know the rules and regulations of the procedure, the cost, etc. Therefore, the institutional arbitration shall have an edge over the ad hoc arbitration. I do not for a moment criticize and or favor the ad hoc arbitration or even the institutional arbitration. The consistent rise of business and trends all over the world and the commercial transactions thus warrant a dispute resolution mechanism which not only is cost effective but also speedy and binding, which with the liberalization of the economy, international commercial transactions have been witnessed to grow, and in such circumstances, resolution of the disputes through unconventional means such as arbitration is to be a preferred choice, which not only provide the parties the liberty to decide the place or the venue of the proceeding, but also the seat of the proceedings which according to them serves their base interest. Therefore, more and more efforts should be made to invite the stakeholders to resolve the disputes through arbitration. Nowadays, number of arbitration centers, international arbitration centers, institutional arbitration centers have been established, which I am sure shall cater the need. One of the greatest advantage of the institutional arbitration which I have seen and experienced is the timely and speedy disposal of the arbitration proceedings. Sri Madhav Keshan is just today said that 92% cases arbitration proceedings were disposed of, correct, within the time limit. I congratulate really from my bottom of my heart this Mumbai Center to achieve this result. Fantastic! It's a wonderful, fantastic result which they have achieved, correct, in achieving and disposing of 92% cases, correct, within the time limit. Congratulations to all the organizations and the stakeholders so far as the center is concerned. I must congratulate my own institution, Gujarat High Court Arbitration Center. In fact, it can be said that it was my brainchild and my baby, which ultimately got the birth, correct, when I left, correct, and the rules were framed by Justice Karya and other brother and sister judges, and they did the wonderful things in preparing the rules. I am always happy that now the progress which I have today seen so far as the Gujarat High Court Arbitration Center is concerned, within 1 year or so, correct, 132 cases, 135 cases or so, correct, it's a fantastic progress, correct, congratulations to all stakeholders and so far the High Court Arbitration Center is concerned. As rightly said by Kamal bhai, and I also join and request all of you to come and see the GIFT Center. And not only every year, correct, but every 6 months you will have a seminar, correct, including the Mumbai Center, correct, to seminar on different subjects on arbitration, in arbitration matters. It's a wonderful center, it's a wonderful place, correct, where you can get every facility, correct, so far as the international arbitrations are concerned. In today's conference, there shall be 4 sessions, and the distinguished speakers will speak on different important topics like privacy and artificial intelligence in dispute resolution, innovative remedies in international commercial arbitration, latest developments in the law of arbitration, and the appointment of arbitrations, more disclosure, more challenges. I share the same views as Kamal bhai has said so far as the AI is concerned. I also, by and large, correct, because very difficult to at this stage to say, correct, that nobody is not advisable to go for AI. But in adjudication process, correct, to have the involvement of the AI and to what extent there shall be involvement of AI shall be discussed in today's conference. I would have been loved to be part of that session to know what are the advantages, to what extent the AI can be used, correct, in arbitration, in resolving the arbitration disputes, and which is by and large is a adjudicatory process. Sometimes there are balancing views, correct, family disputes, commercial disputes, long disputes, correct, and in that, correct, what a human mind can say or see, correct, cannot be seen by the AI. Therefore, correct, with great caution, correct, the AI should be used in an adjudicatory process. It is not always 1 plus 1 equal to 2. Many times one should, for looking to the circumstances, it should be 1 plus 1 should be 11 also, correct. But that depends upon how the mind of the arbitrator works in the adjudicatory process. Today, on such an important topic, you will have a discussion. The distinguished speakers will throw lights on that, and I request Nidhi, whatever the outcome and whatever the discussion, please send me so that I can also know the benefits, advantages and disadvantages of the use of AI, correct, in adjudicating process. The topic latest developments in the law of arbitration is a very important topic, because wherever there is an occasion, the judiciary has stepped in. Right from the interference of the courts against the award by the Arbitral Tribunal under section 34, 37. So far the international arbitrations are concerned, the proceedings under section 45, whether there shall be automatic stay, correct, whether that shall be delay condoned, correct. Recently I have delivered one judgment on 34.3 and whether beyond certain period the delay can be condoned or not. All these things, correct, are latest laws which all arbitrators and arbitral tribunals must know, correct. Even the advocates, the stakeholders, parties also should know, so that they know where they stand, correct. Suppose a view is taken that delay cannot be condoned beyond certain period, correct. That law is clear. That is the latest law. But still, correct, one is to consider the latest law, which shall be discussed in today's sessions also. How, to what extent the court should interfere, correct, against the public policy, against when the allegations of fraud are there, correct, whether two views are possible or not. Kamal has rightly said, and one matter is also before me on morality, and he is absolutely right, correct, that morality changes from person to person. Morality varies, correct, even from country to country, arbitrator to arbitrator, judge to judge. To what extent, correct, it is can be said to be against the morality, correct. That is, but still, correct, I may tell Kamal that there cannot be any absolute proposition of law, correct, what can be said to be morality. But still, looking to the facts and circumstances of each case, correct, and our society, correct, because we have to go by the values, correct, so far as our society is concerned, our country is concerned, and therefore we consider the morality from that angle. Another topic will be discussed would be, very important subject would be privacy and the confidentiality. While using the technology and in the dispute resolution, confidentiality is a much needed facet of the arbitral proceedings. Confidentiality and transparency both are complementary qualities, facets of the same coin. The primary advantage of arbitration is a means of dispute resolution is the element of confidentiality. I strongly believe that the arbitration is unquestionably more confidential than the other dispute resolution mechanisms. However, sometimes no confidentiality in the arbitration proceedings is taken for granted. I strongly believe that there shall not be any compromise on the confidentiality and the privacy, because a party to the litigation comes before the arbitrator or even the institution, correct, they come with a hope that that confidential and privacy shall be maintained at any cost. I am very happy to note that Mumbai Center for International Arbitration and the Gujarat High Court Arbitration Center are holding such conferences on various topics related to arbitration, more particularly in the field of international commercial arbitrations. I wish all the best and all the success to the Mumbai Center for International Arbitration and such institutions in achieving the ultimate goal of early resolution of the disputes. I am thankful to the organizers and the members of the center, more particularly Nidhi, because always, correct, when she talks and says, "Sir, aane ka hai," correct, I never said no, I could not say no to her. This time also, I was having little bit some problem, but I managed to come because I love this institution. Last year also, I had a privilege to attend such an event. I shall always be associated with any activity in the field of arbitration and shall be associated with international arbitration centers, arbitrations like the Mumbai Center for International Arbitration and others, and my own institution, Gujarat High Court Arbitration Center. I once again wish all the success to the today's conference. Thank you. Jai Hind, Jai Jai Gujarat.
Thank you so much, sir. We will now be breaking for tea and we'll start with the first session for the day at 11:30. Yeah, please, on. Thank you, Charvi. Charvi is a case manager and is trained that if the arbitration is running late, you have to do everything to make sure it gets over in 18 months' time. So she made sure that she doesn't allow me to say thank you as well. I'll just take a minute to thank everybody. Justice Shah, Justice Desai, Kamal Trivedi, Devang Vyas, Honorable Judges of the Gujarat High Court. I feel overwhelmed to say that I'm always so happy to be in Ahmedabad, and the kind of a reception that we get here, I personally and the MCIA, I'm always very, very grateful for all of you. For you to be present here at 10 a.m. in the morning sharp and for us to start it, it's always a great start, and we hope to continue to do it, sir. You'll be very happy to know that though MCIA doesn't do its annual conference in Mumbai anymore, but we do our annual conference in Ahmedabad, for sure, and we'll continue to do that. I'm very thankful to Prithvi, who's here. He's always given his unrelenting support to MCIA. I just have to pick up a call and tell him that Prithvi, we have to do this event. And he's like, Neeti Ben, when are you back in Ahmedabad? When should we start planning it? Thank you to Ms. Pawar as well and Justice Doshi, who we started to work with when he was with the Gujarat High Court Arbitration Center, and for Ms. Pawar to give her support as well to jointly organize this event. Just a few thoughts on what the speakers have said today, and like I said, I'll try and keep it very, very succinct to this. Kamal, you spoke about what MCI is doing to encourage this. I can tell you that the reason that MCIA is and what we intend to do is not only to be in the forefront for dispute resolution, but we want to create an ecosystem of how international arbitration ought to be done, and why is it that MCIA or India cannot be in the forefront to do it. And that's why MCIA has been collaborating, cooperating with arbitral institutions across the globe. Justice Desai mentioned about institutionalization. I'm very happy to tell you, sir, that we launched the India ADR Week 2 years back, and we had 30 arbitral institutions from across the globe support an event done by a competing organization. And we're doing it again this year in October, and I would love to have you all present for that as well. We do it in 3 different cities of Bangalore, Delhi and Mumbai. And we again have the support of almost 30 arbitral institutions across the globe to support it, is to making India a place for institutional arbitration. I must also say that whenever I reach out to Devang Vyas and I say that, sir, you have to speak on this topic, and I yes, Neeti, and then I keep changing his topics, and then I put him in a more difficult spot. I said, I'm not going to ask you to speak at the plenary session. I'm going to make you sit in a session and you have to answer questions, which is even more difficult. So he is the one who is going to be answering the questions on AI and intelligence and privacy and confidentiality, and we should definitely report to you as to what Devang Vyas and the other panelists had to say on that, sir. Very quickly also on this, sir, though Madhukeshwar mentioned about 18 months timeline, standing here must also mention that MCI had an emergency arbitrator award. We appointed an arbitrator in less than 24 hours. And we had an award from the emergency arbitrator in less than 10 days. But as things happen, it got challenged. And got challenged at District Court of Ahmedabad. But the story doesn't end there. The icing on the cake comes now. We had the order where the judge recorded that it's an MCIA administered arbitration. The arbitrator appointed is of impeccable authority, independence. We see no reason to interfere with it, and they set aside the challenge itself in just one hearing. So we were so glad to see that the judiciary has been supportive not only of MCI but the institutional arbitration, emergency arbitrator and all as well. So just on the international parties, and my last point I promise, this is Desai mentioned about and Justice Shah mentioned about it, how the international trade is growing and we need to do things about it. So we're very happy to tell you that MCI is not only in Gujarat, Bombay, Delhi, Bangalore, but last month we were invited to be in Paris because a lot of French companies were operating in and out of India. We started with one session planned on India, and we ended up having 4 different sessions talking about business and dispute resolution in India.
And similarly, sir, next month we've been invited by the London Disputes Week to come and talk about what India is doing on the dispute resolution, and we have again a couple of sessions lined up. And later in the year we are in Japan, Germany and Korea. So idea is to spread the wings of India, of institutional arbitration across the globe, and people need to now start coming to India to resolve disputes rather than Indian parties going to different jurisdictions and doing it. And of course, all of this is not possible without the support of each one of you present here. So for MCIA and for the cause of institutional arbitration, we look forward to your support always. Madhukeshwar, I, Charvi, we are here. You have any ideas, please do drop by, talk to us, drop us a line. We're always happy to engage. With that, I will be failing in my last duty if I don't thank my sponsors, without whom it's always very difficult to put all of this together. So to Shardul, Amachin, Mandana, Shruti, Tejas, they're here. To our knowledge partner, Nishit Desai Associates, Vyapak is here. It's his birthday, so please wish him. It's great that I could drag him on his birthday to be here as well. And of course, our other sponsors, we have Montec from Osborne Partners, Vijay is here from JSA, then we have AZB Partners, Aditya is here, FDI Consulting, Ishani, and of course, Clifford Chance, Matthew Brown. So we are very thankful to you for here, and we have 4 different sessions lined up. I hope to see that all of you engage in that. Ask the moderators and the panelists a lot of difficult questions so that we can report it back to our plenary session speakers and say how this conference went by. Thank you once again, and please do join us for tea and coffee.